A, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and before the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Wolahojian. To my left, Justice Brennan. We will be hearing two cases this morning. Now, these are related cases, though they've not been consolidated. So what we're going to do is this. We're going to follow our ordinary procedure, which is, in each case, each side gets 15 minutes, and there's no rebuttal. But it wouldn't surprise me at all if in the first case, some discussion about the second case bleeds into it because of the similarities. And my guess is we won't need all the time of the second argument by the time we're done with the first argument, but we'll give you both the full time on both cases because it's two cases. So the first one, actually let me say both of the numbers just for, I don't know how we use these recordings. The first case, and the one that I'm going to call now, is number 22-268. This is Mackey versus Rouse-Weir. The second case is 2022-450, Mackey versus Joss. And we will hear first from Mr. Mackey in the first case.
Good morning, Your Honors. My name is George Mackey, and I am the pro se plaintiff in this matter. This matter relates to the constitutional violation of rights, medical malpractice, and violations of my due process and violations of ethical standards by the defendant. Other related violation matters are discussed throughout the plaintiff's complaint. Should I use plaintiff or appellant?
Plaintiff is fine.
Okay. On July 24th, 2018, the plaintiff was transferred to the Nemanskett Correctional Center after a hearing as required by Mass General Law, Chapter 123A, subsection 13A. And based upon the written report of the defendant, Dr. Katrin Rouse-Weir, pursuant to Mass General Law, Chapter 123A, dated April 16th, 2018.
May I ask you a question about that?
Sure.
So, because I can't remember people's names, I'm just going to call the defendant in the first case the independent examiner.
Okay.
Correct?
Okay.
Okay, so the independent examiner submitted a report, is that correct?
Correct, to the district attorney.
In connection with, is it a probable cause determination?
Correct.
That's what happened there?
Yes.
Okay, so she, as I understand what you've pled, and some of it is also factual material you've put in your brief, she first submitted a report to the prosecutors, is that correct?
The Worcester County District Attorney, yes.
Okay, to the district attorney's office. And you're not alleging that in that report there were the missing paragraphs, correct?
Correct.
So that one, at least from that perspective, you don't agree with its conclusion, but from that perspective, you're not saying there was anything wrong. Is that correct?
Well, there were things wrong, and that's why we had an in-person interview.
Okay, but because you disagreed with it, but you're not, is your claim that that report that was submitted only to the prosecutors, are you making any claim about the first draft?
No.
Okay, so then you then meet with them, and then she produces the independent examiner produces the second draft.
Correct.
And that second draft ends up has the missing information, and then it's submitted to the court. Is that correct?
Yes.
Okay, and that's the one you're basing your claims against this independent examiner on?
Yes.
Okay, that's very helpful to me, thank you.
Okay.
Can I ask you one more question about that?
Certainly.
So I've read what I think are the 27 paragraphs. It's Appendix A, I take it, to your complaint.
Okay, yeah.
I can't tell, there's some markings on the side about what's deleted, and actually there's more than 27 paragraphs, but I read the whole thing in any event. You describe it as exculpatory, but a lot of it's inculpatory too.
Yes, but if it had been used at the probable cause hearing, if it was contained in the report and could have been used by my attorney to prove that the statements made by my stepson were inaccurate, you know, there was a possibility that it could have been, no probable cause could have been found.
Did your attorney, sir, not have the original report?
He did have the original report.
So the district attorney disclosed the original report to your attorney prior to the probable cause hearing?
Correct.
And did your attorney use that report that your attorney had, not from the defendant's report, but because it had been disclosed and your attorney had it?
He did in the form of asking questions related to that first report, which she testified to as
Not
having not seen.
second page of the police report or whatever. And your allegation, not unreasonably, is that must be false. She included it in the first one. I think we understand that.
Yeah.
I'm just trying to get to, for you to have been injured by her deletions, they had to have made a difference in your being held or not, right? So if they were included in the report and it wouldn't have made any difference, then she may have done something wrong, but it didn't injure you in that way. And I'm just trying to figure out, you know, because it's not like there are 27 paragraphs that say, but video evidence shows this didn't happen, or, you know what I mean? They're not like capital E exculpatory. They're a pretty mixed bag, maybe even harmful in my view, although I don't know the facts well enough to be sure.
Okay, and my opinion is that if she removed those 27 paragraphs after we discussed them, and I explained to her what had happened, and for her to say, if she had said, you know, if she had left the whole thing in there, you know, all the paragraphs or whatever, and not mentioned not having reviewed them, which is, she testified under oath that she didn't see them, but she had.
So
And
what
we
you're
had
saying,
discussed-
is what you're saying that your conversation with her with reference to these allegations, in your view, adequately explained them, that the appropriate response of the independent examiner, whatever we're calling her, would have been either to reach a different conclusion or to write something that showed the weakness of this stuff, and instead, rather than reporting to the court both of these allegations and your response, she crossed out the allegations, didn't discuss your response because the allegations weren't in there, and that's it. Is that what you think happened here? Or I'm adding this stuff about talking to you, I don't want to.
Well, in addition, you know, you have that factor that she removed these paragraphs claiming that she didn't see them, which maybe she could have reached a different conclusion. But she also used other information which was inaccurate and made a misdiagnosis of the pedophilic disorder.
Now, I see that allegation in the Joss case. Is there an allegation here of misdiagnosis in the
Yes.
complaint? Okay. You can go on.
Okay. The defendant's report contained misinformation and material of non-convictions in violation of the statutory requirements and the misdiagnosis of pedophilic disorder, which is not substantiated by any evidence.
I'm sorry to interrupt you. I want to go to a slightly different topic, if I may. I'm not 100% sure when I'm reading your brief what your position is on whether the independent examiner was a state actor.
I don't believe she is.
Okay, so is that because she's not employed by the Commonwealth?
I wouldn't go that way as much as I would go that she's employed by the Department of Corrections, who is
Employed by
well,
the...
she's in, the way I understand this to work is the Department of Corrections vets qualified examiners and independent examiners. You can't do Mass General Law 123A determinations without being vetted by the Department of Corrections, Commissioner of Corrections. So whereas the Department of Corrections has jurisdiction over all of the people charged as sexually dangerous, there is, I didn't mention conflict of interest because that's very hard to prove, but she is definitely not hired by the court or the judge. And in this instance, with her, she's called by the district attorney. It's not like it's put out there for several different.
But they're not, but, okay. But what you're just saying there,
she has her own individual practice.
okay, so that's what I'm trying to figure out. So your position is she is not a state actor?
Correct.
Because even though she's selected, let's just say, by
Right.
the Department of Corrections, or maybe by the
District attorney.
district attorney's office, she's just not a state actor.
Correct.
Okay, did she get paid for her work, do you know?
I believe she did.
And who pays for her? You don't know?
That I can't tell.
Okay, so was there and maybe you don't know this either. So is there, when it comes to the point of retaining an independent examiner, is there an order from the court? Because we don't have those underlying case materials.
In this case, I believe the district attorney makes a phone call. Once they get information that an individual is being released from incarceration, they notify the county district attorney. The county district attorney pulls up the records, however they do it, and make a determination, let's see if this guy meets the criteria for sexually dangerous. Then they make a phone call to whomever to do the paperwork investigation, the forensic investigation.
Okay, but at some point, all of this ends up in court
Yes,
for a probable cause determination.
correct.
But there's no order, are you telling me there's no order issued out of at that stage, out of the court that concerns the independent examiner?
I'm not sure, but I don't think there's a court order. It's not on the docket entry sheet. However, I don't know if there was like a subpoena or something issued for her to come testify.
Okay. We don't, I
don't have
I
that.
didn't see the subpoena.
Yeah,
I didn't see the docket for the case
Yeah.
in the materials here, so I wondered. Okay.
Do they have to hire this examiner?
No, they do not.
The statute doesn't say anything about someone like this. So this is a person, they think, wow, here's an allegation, or whatever, here's a person who's subject to possible SDP proceedings.
Correct.
We don't know whether they're a sexually dangerous person. We're a bunch of district attorneys.
Right.
We need someone who knows about this stuff to come in and investigate everything that happened, and they'll tell us. I think there's probable cause, or I don't, and then if they say no, they don't have to do anything, right?
Correct.
The prisoner just goes free. And if at the end of the, custodial term and so on, but if this examiner says, oh, I think yes, probable cause, then is there anything automatic about this? Or the prosecutor's office, just like in any other case, the police come to them and say, there's probable cause to believe embezzlement occurred or whatever. They look at it and they decide, oh yeah, let's prosecute that, or no, let's not. Is it like that?
I would assume so, yes.
Okay.
So I realize this relates to the second case, but, so then, so there's a probable cause determination made here in your case.
Correct.
And then the qualified examiner they're brought in after the point of probable cause, is that correct?
Yes.
And was that, I take it there was an order from the court regarding
Yes.
that? Okay, okay.
And am I correct, the probable cause hearing results in a temporary detention, 90 days or something, at the treatment center? The statute requires an examination by one or two qualified examiners during that time period, right?
Correct.
So, sort of automatically, once someone is found to have probable cause and is held, I guess the Department of Correction appoints someone to be from their list to be the qualified examiner, and they go over. And am I also correct that the person being held must interview with the qualified examiner, or they can just be found to be an SDP and held without further proceedings?
You do not have to be interviewed. You can refuse the interview. However, if you refuse the interview with the qualified examiners, you are not able to secure two independent examiners on your behalf.
Well, I'm sorry, I don't understand. I thought that you couldn't be discharged at all if you refuse.
No, if the two qualified examiners find that you're not sexually dangerous, they can release you.
And they can do it without talking to you if you refuse?
Yes.
Okay. All right, your time, at least in this case, has expired, and we will hear now from Attorney Gary.
Good morning, Your Honors. Patricia Gary, and I represent Dr. Katrin Rouse.
Could you move the microphone a little closer so that...
Patricia Gary, and I represent Dr. Katrin Rouse. We are, before I get started, I'd just like to point out that even though we object in our brief to some of these materials that were attached to the complaints in these cases, the record appendix for Dr. Joss at page 48 has some deposition, a deposition transcript or portion of a deposition transcript of Dr. Joss in a different case, and he actually does a nice job of explaining this process that you were asking questions about, Justice Wolosian.
I'm sorry, page 48 of the record appendix?
For Dr. Joss, it is
Oh, for
deposition.
Dr. Joss.
I mean, I found it helpful. I was reading it this morning, actually, and I thought that it did a nice job of explaining it. And some of the other case law that we've cited in our brief does too. In any event.
Yeah, I'll look at that. Turning to the merits of this case, your position has been a moving target throughout this litigation. What type of immunity do you say that the defendant has here?
We say that it's quasi-judicial immunity, and so quasi-judicial immunity extends to individuals who perform functions that are closely associated with the judicial process.
Okay, but she's not appointed by a judge, hired by a judge, designated by a judge, called in by a judge. The DA's office hired her to do an investigation, right?
Right, and in this case, Lalonde v. Eisner is the leading case about medical experts.
That person was appointed by a judge.
Right, and in this case, there's a statute, and it makes it particularly applicable because the entire statute of General Laws, Chapter 123A, it couldn't really function, and there is a functionality test for quasi-judicial
No,
immunity.
but everything in the law couldn't function without the police. But they don't get quasi-judicial immunity. They're not, what they do is...
They have qualified immunity, though.
You're not asking for qualified immunity?
No, we're not.
Okay, so maybe she has qualified immunity, although she's not employed by the office. But this quasi-judicial piece of it seems I don't quite get it. She's certainly not appointed by the judge.
She is appointed by the DA.
Does the DA have quasi-judicial immunity or prosecutorial immunity?
They have prosecutorial.
But you don't say that your client has that.
Actually, we argue that for Dr. Rouse-Weir, that she's entitled to quasi-judicial immunity for two separate reasons. First, because she functioned as an expert, as in Lalonde, a medical expert.
Wait. So you're not saying prosecutorial immunity even here, right?
But then second, for a second reason, that she was functioning as an arm of the court by assisting the district attorney in this very important...
Do police are they an arm of the court when they assist a DA? The DA says, all these photos and stuff have been delivered to my office. I can't make heads or tails of them. We'll get some examiner at the police department to take a look and determine whether, in fact, what we're seeing here is a drug deal.
Interestingly, I think there is one good case that was actually discussed by my partner at the oral argument for this case, and that case is Rodriguez versus Furtado, and it explains both qualified immunity and quasi-judicial immunity within the same case. So it's a good case for that.
I'm asking about police investigations. Do the police have quasi-judicial immunity?
I believe that the police have what is called as qualified immunity.
Yes, and maybe your client has that, but why do you think she's any different from a police investigator? She's hired.
Because she's a private individual. The police work for the government.
Was she paid by the government?
She was paid by the government, but she's a private individual.
Private individuals don't have prosecutorial, quasi-judicial, qualified, or any other immunity that I'm aware of.
Well, in this situation, we're not talking about the police, and that's,
But you said she's a private individual, which I agree with, but it seems to me that makes your case weaker, not stronger. Do you know about McKnight, in which the Supreme Court held that security guards at a privately run prison that was contracted by the state have no immunity at all?
I'm not aware of that case, Your Honor, but in this situation, we have a statute, Chapter 123, and that statute is required, it's a public interest argument that without...
Don't you think that the prison guards in Tennessee were operating pursuant to a statute?
Prison guards aren't medical experts. They're not medical experts.
No, but they beat prisoners sometimes.
I can't speak to prison guards.
Well, but they do. They discipline prisoners. There's maybe violence. There's a million ways in which, in the exercise, even proper exercise of their job, they're interacting with prisoners.
Well, that would be a violation, a constitutional, violation, because that would be beating someone.
Do you agree that we're talking about an alleged constitutional violation? The immunity you're seeking is from being held liable for a constitutional violation, right?
Not an expert in that area, honestly, but
Well, okay, so let me ask you a different way. What do you understand the claims to be? Because my understanding of immunity is that it's tied to the particular claims. That is, the scope of immunity under the state statute might be different from the federal statute.
Well, there's a public reason for it. It derives from the common law, and it's not a statutory right, but without having this immunity, it's absolute immunity, the medical experts in this case would not be able to do their job, nor would they even want to do the job. It would be impossible to hire them.
I guess the DA's office is going to have to hire an expert then to work in the office, and that person will be able to have immunity. I mean...
It has extended to public prosecutors, government lawyers performing duties in civil actions, arbitrators, court clerks, guardian ad litems.
All right, I mean, I think there's an argument, maybe a good one, that she's working for the prosecutor's office even though she's doing it as a contractor. Now, in fact, in Massachusetts, we have appointments of people as things like special attorney general, and that seems to give them some kind of official capacity. I don't think she has any such appointment, but let's say functionally she's a part of the prosecutor's office.
She's functioning as an arm of the court. essentially.
I don't understand why you keep saying that. Do you think prosecutors are an arm of the court, or do you think they're in the executive branch?
I think you have to separate the prosecutor from her role in this.
She
in that-
works for the prosecutor.
It's true, but her report is also admitted as evidence.
If the prosecutor wants to admit it.
Let me ask,
I don't get this.
If, I'm going to ask you a hypothetical. Okay, so, we all know that the DA's office and the Department of Corrections are within the executive branch. They're not part of the judicial branch. At Lalonde, on which you rely, involved the probation department, which is actually within the court system. Here, as I understand it, there was no court order appointing the independent examiner before she prepared either her first draft report or her second draft report. Am I correct about that?
You are correct.
Okay. So how she is, as far as I can tell, brought into the case is through the DA's office. Is that correct?
That is correct.
Okay. So you may still be entitled to some form of immunity, although brought in through the DA's office. But I'm having a hard time understanding how you say that she is part of, that she's brought in through the judicial branch. That doesn't seem correct to me, because unless you have a court order bringing her in.
Well, the probable
How
cause.
can that be? And to the extent she's brought in through operation of statute, the statute was created by the legislature. So that also is not the judicial branch. So can you help me with that?
I can, because the probable cause determination is made by a judge. Is that correct?
After all of these things bringing her into the case have occurred.
So she's assisting the court.
Well, she's not assisting in any way other than any other witness who appears in court and provides testimony.
Well, that is why we've argued that she's
So if the
entitled to immunity
prosecutor
for
had
two different
employed,
reasons.
for example, a ballistics expert in a case,
Mm-hmm.
and that ballistics expert came and testified in court, would you be arguing that the ballistics expert is part of the judicial process?
In this situation, it's the way that the statute
I
is-
understand the statute, but
She's considered an expert. She is an arm of the court in the sense that she is
in order for you
assisting
to
the court.
prevail, do you need us to find that she's an arm of the court? Is that
Well,
essential?
that's-
Because
that's
I think
just
in that case, it's going to be a
That's
tough.
language from the, I'm just trying to use some of the language that is in the cases. She's an integral part of this process, and it is assisting the court in the probable cause finding, and the court couldn't do that without her.
May I ask a question or two? Isn't there a distinction between Dr. Rouse-Weir's role, and you use the word appointed, but isn't she in fact retained by the DA's office?
She is retained.
As opposed to Dr. Joss, who was appointed
I
by
don't-
DOC from a list which is really more statutorily required.
That's also
So
linguistic.
they're two very
because-
different, right? He's not retained by anyone, he's appointed. There's a difference, right?
I think of them as both being retained, but
When there was an order committing Mr. Mackey to a temporary detention at the Mass Treatment Center, that order also required that he be examined by two qualified examiners,
And the
correct?
qualified examiners have the gatekeeper role in the sense that, but I also think that this is gatekeeper role too. So I look at them as both gatekeeper roles, because you couldn't get past the probable cause hearing without
But to
Dr.
Justice
Rouse-Weir's-
Wolhogen's original question, how is Dr. Rouse-Weir's role any different from
The
a
qual-
ballistician, who is not a state police ballistician, a private actor, a DNA expert that works for a private company? I can give you a laundry list of all sorts of
she's
experts
using her own
whom the DA's office retains Okay? They're not an arm of the DA's office, they're not an arm of the court. They're private experts who are retained by one side or the other to provide testimony in support of a position, as opposed to, at least theoretically, Dr. Jost, at least in his role, because he does other roles as well on both sides historically, but his role in this gentleman's case, in which at least he was appointed by statute. Isn't there a difference, a fundamental and material difference there?
I'm not sure if I really understand your question, but I do think that he is,
Let me ask you a different question then. And I'll throw it out there, sort of, to me, the elephant in the room, if you will, which is neither side really addresses, and the judge in one case and not the other only drops a footnote on litigation witness immunity, which is absolute and which it seems to me to apply to both people here. What do we do with
we
that?
also briefed that, but we didn't think that we needed it because we felt that this qualified judicial immunity applied, and I
You
don't really...
didn't brief it in this case?
No, I briefed it in one of the
Yeah,
cases.
Joss, the one in which the judge dropped the footnote, but not here.
Okay. All right.
Can I ask you this? Was the, I mean, I gather this isn't,
Well, Your Honor, I would also say that we argue that the court can make its decision based on anything that's
yeah, but not when we invent it. You have to raise it.
inventing it.
Did
But I'm
you
just-
raise the litigation privilege below
We raised it
in this case?
I think that the court actually might have brought that in.
Did anyone try to join the Commonwealth as a necessary party here? I mean, it seems to me there's something very odd about this, and it's like when I ask you about constitutional claims, of course, that's not your area of expertise, but these immunity issues, I would have thought that the Commonwealth would want to be involved in order to protect its interest, if it has one, in hiring outside experts.
I think it's all part of the statutory scheme, and I wouldn't treat the qualified examiners really as any different than Dr. Rouse-Weir, because they're all part of the same system.
I just asked if the Commonwealth, if anyone sought to join the Commonwealth.
No, we did not. This is at the motion to dismiss stage, though.
Yes, I understand.
And it maybe if the case proceeded, then I guess the Commonwealth could intervene if it wanted to, but.
Okay, your time has expired in this case, but we'll be seeing you again shortly. Thank you very much. We will return now to you, Mr. Mackey, if you'd like to talk about the Joss case. I will call it. It's number 22-450, Mackey versus Joss.
Again, good morning, Your Honors. I'm going to skip through some of the highlights here,
A question for you.
okay?
Somewhere in your briefing, you say that you have named the defendants individually and in their official capacities.
Okay, that must be an error, because it's only the one defendant.
Okay, but okay, so are you naming either defendant in
No.
some kind of official capacity?
The only defendant in this case
I
here
know,
is
but I'm asking you about this one and the other one. Are you naming either defendant in some kind of official capacity?
Yes.
Which defendant?
Well, it would be either one, because
In the Rouse-Weir complaint that I'm looking at, you or whoever wrote this wrote, Dr. Rouse-Weir is being sued in any official capacity she may be entitled to and in her individual capacity.
correct.
I don't know, I haven't
Well,
looked yet.
see, I'm not sure if she was entitled to, and that's why I brought the case.
I'm not sure of that either.
I was just trying to cover my bases.
No, of course.
And I
Do you
would
want to
say,
talk about the litigation privilege? You didn't respond to that argument.
I didn't see that. Alls I saw was the qualified immunity in the original motion.
No,
And that's-
Here, their brief raises litigation privilege. You didn't file a reply brief saying, oh, that doesn't apply.
No, I didn't, because I didn't see it. I must have missed it or whatever. However, in my opinion, once Dr. Joss in this case, or Dr. Ware in the other case, violated any statutory rule, regulation, constitutional right, immunity was removed. And then in the case, which I just found, and I believe I put in the reply brief, was the Annie Dugan, Sonia Farouk, and the Assistant District Attorney, I can't pronounce her name. I'll find it here in a second.
We know those cases.
Yeah, we can.
They lost their immunity. They all testified at trials. They broke statutory laws. They were convicted, and there was no immunity given to, no judicial immunity,
Those
no
were
qualified.
criminal cases?
What's that?
Those were criminal cases?
Yeah, with the drug.
Okay, so we're talking about something different here, right? So I don't think anyone has immunity from criminal prosecution, but people have immunity from civil liability.
Some people.
Some people, yeah.
However, isn't immunity waived if you break a statutory, constitutional law, anything like that? That's the way I interpret it.
Mr. Mackey, can I ask you a couple of questions, maybe again a little off topic, but on the specific claims that you bring a claim for perjury, but I don't understand that there is any civil action for perjury. It's a criminal offense, for sure, and any response to that?
I don't. I just raised it because
Okay.
I believe, perjury caused me to be detained. Now, whether somebody else wants to deal with that and I can't claim, perjury, that's fine.
As
But I
far as
want
the
it
medical malpractice, I didn't see it in the briefs, and I may have missed it, or in the appendices. Was there any medical tribunal at any time?
No, not in the lower court, which I know they're supposed to do.
Okay.
And the medical malpractice is misdiagnosing a disorder that this court released me from, ordering a new trial.
To be fair on that one, it was not on the misdiagnosis or the facts. It was on
No,
the introduction of
the
evidence that
evidence.
was inadmissible.
Right, and
okay.
that's the evidence that he used to get me civilly committed.
But there is a difference between an expert being able to use information to form an opinion as opposed to that information in its original form being presented to a fact finder as an evidentiary matter.
Okay.
Right? Okay.
All right.
Fair enough.
So can you tell me, in your own words, the 1983 claim,
Yeah.
what is the underlying violation of law,
Loss of liberty,
loss of liberty?
which was after this court overturned the sexually dangerous finding, and we went back to square one, and I was interviewed by two qualified examiners again, both using the same information that was provided to both Joss and
Came
Rouse
to a
Ware.
different conclusion. I
Right.
get that. So,
Based on the
and with
statute.
respect to the independent examiner, what she did in your view that resulted in a deprivation of your liberty is by, in the second report, saying that she didn't know about the information in those 27 paragraphs, correct?
That as well as the misdiagnosis.
That she, that
Right.
she thought you were satisfied the requirements of the statute. And for the qualified examiner, it's that he erroneously opined that you met the requirements of the statute. Is that correct?
Right, based on the
Okay.
information that he used, which was actually incorrect. And he testified to that there was no evidence of prepubescence, and there was no evidence of longer than a 2-week or 2-month, I think he said 2 months, it was 2-week period of abuse, which is one of the 3 requirements needed to find somebody with a pedophilic disorder. So based on that, I used the medical malpractice umbrella, I guess.
May I ask, as you understand the statutory scheme, or how it applies, how the statute works, better way to put it, as between Dr. Joss's role in this particular case and Dr. Rouse-Weir's role, okay?
That's why I separated them.
Right. So Dr. Rouse-Weir is in a position where the DA's office could choose to hire an expert or not choose to hire an expert. Fair?
Correct.
Okay. As opposed to Dr. Joss, whose role really is once, again, if I understand it correctly, once there's a probable cause determination, that automatically triggers an appointment, which is mandatory. It happens to channel through DOC because that's where you're housed.
Right.
Right? But ultimately, that's not a choice. That is a requirement. Is that fair?
That is fair.
And that's what distinguishes that in some ways from Rouse-Weir, because again, once that happens, then the DA can choose to hire someone, not hire someone, go with the original one, whatever they may decide based on all that. Fair?
Correct.
Okay.
But basically what I did was, in Dr. Joss's case, the argument is he misdiagnosed the pedophilic disorder. Without a pedophilic disorder, I'm not a sexually dangerous person. Two other doctors and my two independents all said, or three other doctors, two QEs, yeah, the two new QEs and my two independents, no sexually dangerous, and I was released.
Are you alleging that he did so intentionally, or simply he made a mistake, or he misread the signs?
I'm not saying he did it intentionally. What I'm saying is he's had other cases where his determination has been thrown out because of errors in his report. So this is not the first time he's made this error.
The judge below asked you whether you had a physician-patient relationship with these doctors, and you said that you hadn't really thought about that or didn't really know.
Except for the fact that I'm required to see, not required, but I chose to see them. If that's a patient relationship, that legally I can't answer. I just don't know that.
Okay, I think we understand the arguments in both cases. If there's more you want to tell us, though, you can, but...
A couple of things, just...
Of course.
I have in re Redgate, which is a psychologist may not assume an instance of sexual misconduct that, as here, judicial process has determined not to have occurred or been proved. So both doctors know, and I mean, this case is from, I forgot to put the date. It's 35 Mass Appeals Court 495, page 501. All right? So I think that was like 93. So this law has been around, and these two examiners have...
Is that a criminal case or a civil case?
Redgate. I do not remember. And then I have the case about Span v. Davis. Did the Court of Appeals error and conclude, and this is out of, I believe, Georgia, that the trial court was correct to rule sua sponte on the same issue of quasi-judicial immunity, even though the defendants did not raise judicial immunity. At the original hearing, it was qualified immunity, and then they brought it up, but not in the form of a motion. They just argued it, which prejudiced me as far as, I'm a pro se litigant. You know, I don't have all of this stuff on the top of my head. You know, I mean, it takes me a while to do the research. I know that's not an excuse, but, you know, I'm going to use this one. And then I have the same thing with my main argument for Dr. Joss is the fact that he violated my constitutional rights. He violated, you know, he took away my liberty for over 2 years, you know, on a misdiagnosis. Everybody else came to the same determination except for the independent examiner, who I think changed the record to make it fit what she wanted it to fit. And I'm a free man now. But it cost me 4 years of my life to do this.
Okay, I think we understand that.
Okay.
We always appreciate pro se litigants coming in. We know it's difficult for you because you're not trained as a lawyer, and it may be intimidating, so thank you very much.
All right, thank you, Your Honors.
Of course, and we will hear again from Attorney Gary.
Your Honors, I'd just like to, again, getting back to the whole prosecutor role. In a recent case, Padmanian, I'm not sure if I'm pronouncing this correctly, Padmanabhan versus Cambridge, an appeals court case, the court held that the Supreme Judicial Court has not hesitated to extend this absolute immunity to officers who are involved as an integral part of the judicial process, and cited Lalonde.
Who are the defendants there?
This had to do with the Board of Registration of Medicine, and it extended quasi-judicial immunity to a clerk and to a board that, a license.
A board that makes
licensing-
quasi-judicial determinations,
Yes,
and
for-
its clerk.
For medicine. So, and I just wanted to say that the Supreme Judicial Court granted absolute immunity to arbitrators as quasi-judicial officials exercising judicial functions. The doctrine has been repeatedly confirmed and expanded. It encompasses court clerks acting at a judge's direction, public prosecutors discharging official duties, and government lawyers performing duties in civil actions.
Have you given any thought to the Dukin analogy? Annie Dukin?
I'm not sure what that is.
Okay, Annie Dukin is the chemist at the state laboratory who
yes,
falsified drug tests, tests of substances to see if they contained illegal drugs. So she was, in some sense, an expert doing some investigation. She
That's
falsified it and people were held.
She intentionally falsified.
That's the allegation against
that's a
at least
crime.
Rauner, is intentional falsification of her report. By deleting these paragraphs. But if she had absolute immunity, well, I'll just tell it the other way. I just looked for 2 seconds. I found a federal district court case from the District of Massachusetts that denied her supervisors qualified immunity. The allegation was that they knew she was forging documents, but allowed them to be used in court to put people in jail. And the court said, since that would violate clearly established law, even though these officials are entitled to qualified immunity, they're subject to a tort suit. And I'm having as I think about that, that seems right to me, that qualified immunity is quite good immunity, but you can't violate a clearly established right. And I guess I'm just not sure. Why don't you think this is just an ordinary case of qualified immunity if we count her as...
I don't see a large distinction between the two.
One is absolute immunity, and one is qualified immunity if you don't violate a clearly established law.
And that's why I want to bring up this, once again, this SJC case, Rodriguez versus Furtado, in which the court said the judge below granted summary judgment in favor of Dr. Falkhoff. The doctor performed like a cavity search pursuant to a warrant. The police officer that was involved was given qualified immunity below, and then the doctor was given this quasi-judicial immunity.
Because there was a court order, a search warrant.
Right. And the SJC said we need not decide whether Dr. Falkhoff should receive absolute immunity since he is entitled to qualified immunity, which is sufficient to protect him. So if that's what you're saying here, that...
I'm not saying it's sufficient. I'm saying that I don't know the facts well enough to know if it's sufficient. The judge below rejected qualified immunity, and you didn't argue it.
Well, we are saying now that either or.
Yeah,
I mean, we will argue either or.
Okay, it's not what you will argue, it's what you did argue.
Well-
You don't raise qualified immunity even in a footnote.
That's true.
I know,
But
so you
however,
didn't
we're just
argue.
asking you to affirm the lower court.
Yes, we could affirm on any ground, but you
you
have
can
to raise it.
affirm.
In my view, at least, you have to raise it. We don't go roaming through
Well,
the
I also
statute
don't think
books.
that you should reverse and put litigants in the court through unnecessary litigation.
Well, you shouldn't
if-
write a brief that says qualified immunity, then come in and argue it a different way and put the courts, and then appeal it instead of filing a proper motion, maybe under some privilege that does apply. I mean, I don't know what to tell you. The waste of litigation resource doesn't really seem to me to be on us.
I'm not really abandoning our quasi-judicial immunity argument.
No, of course
I
not.
think that it applies.
That's
And
your only argument.
But I also think that these two doctrines are not that different, in my view, at least. They're a common law doctrine of immunity, and it's been created by the court. It's a judicial doctrine. It's not in a statute somewhere. It's been extended many times.
Why did the judge not find qualified immunity?
Why did the lower
Yeah,
court
why
judge?
did the judge, that's what you argue, and the judge didn't find it.
Right.
Why?
Well, because she felt that quasi-judicial immunity applied.
Well,
And,
she must have first felt that qualified immunity was the wrong.
and that was because I believe her reasoning in that sense was that it's for the government.
That
And-
it's-
For the government. And that our doctors.
Oh, I see. So that's the McKnight point. Maybe she'd be entitled to qualified immunity if she worked for the government, but she's a private party. She just doesn't get it.
Correct. That it
Well,
doesn't
maybe she
extend to
doesn't get it. I
private
don't know about
parties.
that.
However, I think Rodriguez versus Furtado, we're going to rely on that. That was in our oral argument below. It's either or. I mean, if you don't
Did you
want
cite that in
to.
your brief here?
Is it in my brief? Yes. And we also we several times reference the oral argument and say that the judge did not sua sponte raise quasi-judicial.
I don't see, I'm looking at the table of
Both.
authorities in your brief.
Oh, whether I cited that case itself?
did
I don't
you?
think that I did, but I think I referred to it within I know that I filed actually a supplemental appendix in both cases just to put the transcript.
I don't care about the transcript. Do you understand there's a difference between an argument made on appeal and whatever you say to the judge below? We can really only deal with arguments that are made to us.
Well,
So I didn't see, I was
understand
just
that,
asking you.
but I also
I was
cited a lot
simply-
of cases.
Excuse me.
Okay.
I was simply asking you whether you cited to that case in your brief. I didn't see it. I'm looking at the table of contents.
I may not have, Your Honor.
Okay.
But I did
Do you
cite to
have the
the,
case cite?
okay. Would you like the case cite? I'm sorry, that, it is in the transcript of, which I
Again.
actually
Do
filed.
you have the case citation
Yes,
for this
it's
Furtado?
It's 410 Massachusetts, 878, Rodriguez versus Furtado. And it states, once again, that we need not decide whether Dr. Falkhoff should receive absolute immunity since he is entitled to qualified immunity, which is sufficient to protect him from liability. And this case is good because it has both in it. It explains that the police officer below was given qualified immunity, and then the doctor was given quasi-judicial immunity, and the SJC said, we need not decide either way. So I would say that, I'd like to rely on this case. It's not clear. There has been no other cases that the appeals court has not yet addressed this issue about this statute. So we're not, we're arguing what we have, what the law is, what the common law shows us. And I don't think that we can really be faulted for that. The lower court judge thought that quasi-judicial immunity applied. To me, I think it does.
I said not to be picky, but when you say you can't be faulted, you can certainly make a record in front of the judge there, and then you can certainly argue it and brief it here, right? I don't understand your point.
Well, we think that the court, which is yourselves, the justices, can look at the record, and you can decide and affirm on any grounds that you want
Are you
to.
not-
That's not actually a correct statement of the law.
Okay.
Okay? Because what you're omitting is any ground raised below. We're not lawyers. We can affirm on any ground that was fairly raised below. That's what the full statement of the principle is.
Well, I think this certainly was raised
It
below.
wasn't raised here.
Well, it was raised below.
You can have trial court waiver and you can have appellate court waiver.
Okay.
Appellate
Well-
court waiver is when you don't argue something here. Trial court
right.
waiver is when you don't argue something in the trial court.
All right, well, that's fair. The lower court,
Many people
Decided-
argue something in the trial court that then, for whatever reason, strategic or something else, they decide not to pursue on appeal. We don't undo that. If you don't argue something on appeal,
well, I mean, to be honest with you, I do think that the prosecutors discharging their official duties and all of these other citations that we've provided lead me to believe that it's quasi-judicial immunity, Your Honor. But again, in Rodriguez versus Furtado, the SJC didn't say that you've waived it because,
Well, we didn't read the briefs in that case.
Right.
What they did say was, while private parties such as Dr. Falcoff usually are not entitled to the defense of qualified immunity, Dr. Falcoff in this case performed a duty customarily carried out by a public employee, namely the execution of a warrant. Policy and fairness considerations militate in favor of extending immunity to physicians who, pursuant to a warrant, conduct searches of body cavities. But that's qualified immunity, which you didn't argue here. This is interesting to me, because if it's subsequent to McKnight, then maybe it tells us something about the scope of Section 1983 immunity.
yeah.
Qualified immunity.
I guess what I'm saying is that in this case, the way this statute operates is the court needs these medical experts.
Well, it needs a QE. It doesn't need an independent examiner, right? That's the decision of the prosecutor's office how to investigate.
I suppose so. You're making a big distinction between Dr. Joss
Yes, of course.
and Dr. Katrin Rouse-Weir.
Well, they're doing two different things.
In a sense, they are, but the court is making the probable cause determination and
but
can-
that's after she's performed her work. I mean, I think we don't need to go over this
Okay.
again, but
Okay.
she's not, there's no court order before she's, of any sort, before she is
Well, under the-
retained, brought into the case by the DA's office, correct? There's no court order.
I mean,
Whereas
correct, but
Whereas with respect to the qualified examiners, there is a court order. There's the court order of temporary detention that includes a requirement that two qualified examiners be appointed. But in the case of the independent examiner, there's no court order before she does her work.
I agree with you, but it's part of the statute that this has to be done. And it's a statute that has to be followed.
Can you give me a cite to the section of the statute that requires the DA's office to retain an independent examiner?
Yes, I will try to. I believe it's I think it's section 12.
Let me look. It requires that an independent examiner
petitions.
be retained?
There's section 9.
Let's look at it.
And then also Section 12, notification of district attorney and attorney general 6 months prior to release of certain sexual offenders. An agency with jurisdiction. I know that I think
I'm
it's
just pulling it up
6
so I
months
can
prior
see
to
it.
the release of a prisoner who has been convicted of one of these offenses.
I'm just looking for the specific language you're relying on.
Okay.
I'm in Section 12. Which subsection are you relying on?
I think 12.
Okay, which language in particular? Is there language that says the district attorney's office
Notice shall be given as
must
soon as-
retain an independent examiner?
The agency with jurisdiction shall identify those prisoners or youths who have a particularly high likelihood of meeting the criteria for a sexually dangerous person.
Right, that's DOC had to identify the person.
Right, and so I
But
believe it's,
do you understand? My question may not be clear. My question is the specific language that requires DOC to retain an independent examiner.
I don't have it at my fingertips, but I believe it is definitely within this statute. And I thought it was in Section 12, it may be in Section 9. Oh, no, that's for the discharge.
We can look at the statute.
Well, I guess I don't have the entire statute before me right now, but I know that it's part of it. I know that it is a requirement that this be done 6 months before a prisoner is released who has been convicted of one of these sexual
Okay.
crimes.
Your time has expired, but if there are other questions from the panel, none. Seeing none, thank you very much, Attorney Gary, for an excellent argument, and again, Mr. Mackey, for your excellent argument. The case is submitted. We stand in recess. I'd like to thank the court officers and staff for their assistance today, and we are.